Hey everyone, it's Mr. Dunkel. Today we're going to look at some famous court cases regarding copyright infringement and discuss some of the issues that came into play. So the first one we're going to look at is one of my favorite ones. This was where the Beastie Boys, which was a rap group in the 80s and early 90s, created a song, and then later another company called Goldieblox used that song. So I'm going to play just a short clip here of the Beastie Boys. They had a song called Girls, and I will let it play for just a moment.
Girls, yeah, all I really want is girls, and in the morning it's girls, 'cause in the evening it's girls.
Okay, so the Beastie Boys did that song, and it goes on to just talk about how much they love girls and they think about girls all the time. And then several years later, just a few years ago, the Beastie Boys song was done in 1987. And this was a commercial that came out just a few years ago. And see if you notice a difference. So as you can tell there, they pretty much just rip off the Beastie Boys song, and they just change the words for it for their commercial. So when this court case comes to play, what's interesting is the Beastie Boys write a letter to Goldieblox, and they don't threaten court. They just basically say, "Why have you used our stuff?" Because the Beastie Boys had decided as a group that they would never use their work for commercial purposes. And actually, one of the Beastie Boys died, and even in his will, he put that he did not want his picture or any of his music ever used for commercials. So when they see the Goldieblox commercial, they write him a letter, and they're like, "Why are you using this? Why didn't you ask permission?" So Goldieblox, in a really interesting move, decided to go ahead and sue the Beastie Boys, which is really odd because you would think it to be the other way around. But what Goldieblox was trying to do is just go ahead and get it into court so that hopefully the courts would rule that it was a parody. And when that happened, the Beastie Boys, of course, they got upset about that because they're like, "All we did was send you a letter and now you're suing us." So they countersued to say it was copyright infringement. So when we look at the 4 points that might be considered for this one, basically what it came down to in the courts is that the courts decided that point one was especially at play here because the work they were doing was not parody. It was for profit. They were simply trying to make a commercial so that they could sell their product. So Goldieblox, they make educational toys for girls and try to help girls, do better in math and science and things of that nature, and realize that they're just as capable as guys of doing all that kind of thing. And so that was the whole purpose of it. So what ends up happening is the Beastie Boys win the court case, and Goldieblox somewhat comes out a winner too, but a little bit smaller of a winner here. But here's what's interesting with this case. One of the reasons I have a lot more respect for the Beastie Boys. I grew up with their music, but definitely respect them more after this court case. What the Beastie Boys said to Goldieblox is they said, "We want you to do two things." This was the kind of the agreement of the court case. Number one, offer an apology. We want to see a written apology on your website. The Beastie Boys said, "We love what you're doing. We think it's great that you're helping young girls, realize that they're just as good at math and they can code apps and they can design things and be engineers just like guys can. That's wonderful. But they said the way you did it is wrong, and we don't like the idea that you're promoting it's okay to steal other people's stuff." So that was a valid point, and Goldieblox did that. The other thing they did, which I really, really liked, was they said, "You owe us money." Obviously, when you have these court cases, usually the loser has to pay, money for infringing. And they said, "What we want you to do, though, is rather than give it to us, we're going to pick a few charities that we like that help girls, young girls, to do better with engineering and science and architecture and those kind of things." And so rather than the Beastie Boys taking any money for it, they simply turned around and have it go straight to a charity that is going to help young girls. So in a sense, Goldieblox, was a winner there as well. Now let's look at another court case. This is one, and this particular one is one about a tattoo. That's what this question here was asking. If you were in class, we're going to talk about different things. And most people don't think of tattoos as being copyright protected. But as you can see here, this is a tattoo on Mike Tyson. And in the movie The Hangover 2, this is the exact same tattoo. And so what happened was, it wasn't Mike Tyson that sued, because Mike Tyson wasn't the one that created the tattoo. The person who created it, the tattoo artist, sued Warner Brothers, and they basically wanted them to not even release the movie. So they had one court case to decide whether the movie could even be released. And the judge decided that, yes, we are going to allow Warner Brothers to release the movie. However, the judge did say that the tattoo artist had a pretty good case here. So if he did want to go forward with it in another court, he might have a good chance of winning. So what happened here was the courts looked at, the situation here, and it kind of gets back to, how much of the original is used. And in this case, it was an exact copy. So a lot of it was used. It was used for a product that would help, make profits and things of that nature. So the courts would be ruling in favor of the tattoo artist. So before that happened, the final verdict, Warner Brothers decided to, let's just go ahead and settle with the tattoo artist. And so the tattoo artist got some money from Warner Brothers. Warner Brothers is also a winner here because they were able to release the movie, which became the highest grossing R-rated comedy in the history of movies. So Warner Brothers made over $500 million on the movie. The tattoo artist also won got money from Warner Brothers. So both, in a sense, were winners here. Now, I pose an interesting question here because in class we talk about, who else might be upset about this whole copyright issue, though? We're talking about this tattoo right here. Who else might be upset about that? And you might think Mike Tyson, but it wasn't Mike Tyson because he's, he just purchased the tattoo. He wasn't the creator. The people who were actually upset about it were the Maori, which are the indigenous tribe of New Zealand. Think of like Native Americans here. The Maori is that for New Zealand. And that design is that the tattoo artist uses based off a Maori design. And so the Maori were really upset about the whole court case. They kind of thought the tattoo artist was a little bit arrogant in claiming that he owned that design, because they said these are designs of our culture. How do you claim that you own something that's been around in a culture for, hundreds and hundreds and hundreds of years? Be similar, to people stealing something of our Native Americans and then saying, well, I'm the one who created it. And of course, the Native Americans say, well, no, it's been around forever, never, never. So the Maori were kind of upset about that, and rightfully so. But in our American courts, the Maori couldn't sue, and they didn't, pursue anything like that because they couldn't. But in our courts, the tattoo artists, in essence did win. Warner Brothers settled out of court, and they were able to go forward with that. Now, in our last example, we have a company here called Luxo who sues Walt Disney. And I'll show you just a short little clip here. This is a clip from a Pixar animation. Oops, let me go back to that. And so notice the lamp and how it moves and things like that here. Well, this is Pixar's very first animation, and Pixar decided to not only use the lamp in the animation, but also make it part of their design, their logo design. Well, the company who makes the lamp sued them. They said, you've stolen our lamp and you've used it. And so they sue Walt Disney Company. Disney, realizing that they have totally stolen it, also, looking at these points, realized that, how much of the original is used, almost exactly the original was used, and it was for profit, wasn't parody. So Disney settles out of court with Luxo, and Luxo makes money, off of the Pixar sales and things of that nature. So those are just 3 examples. Again, what you're going to be doing in class is you're going to then find a court case of your own that's happening, and you're going to go through these 4 points and kind of come up with what you think is the most valid point. Look to see what the courts did as well, and then decide if you agree with what their decision was. So hopefully those examples will help clarify things for you. And as always, if you have questions, don't be afraid to ask.